I told you that an individual who suffers an extreme result after having an encounter at a major company cannot sue because of Disney Plus membership. This is insanity. Put it up full mass. So Disney claims the family cannot sue because of Disney Plus membership per law and crime. Disney is arguing that a Disney Plus membership could protect the company from legal action in the event of a Disney-related death. This claim is being challenged by the family of Dr. Kanokporn Tangsuan, who died October 2023 after allegedly consuming a meal at a Disneyworld restaurant that contained nuts and dairy, well-known allergens to which she was deathly allergic. With millions watching and many people benefiting from this program called Indisputable, we just need 1% of the viewers to become a paid member so we can continue to bring this content to you. Now back to the show. Rather than contest the facts or litigate the merits of those allegations, however, Disney wants the case decided by their preferred arbitration organization. This result is mandated in this case, the company says, because the deceased widower signed up for Disney streaming service, and in doing so, signed a contract which agreed that any and all disputes with the company would be decided through the use of mandatory, binding, third-party arbitration. Attorneys for the deceased woman's estate are in turn imploring a judge to reject what they call an incredible argument. They say Disney's position would mean that anyone who signs up for a Disney Plus free trial will have forever waived the right to a jury trial enjoyed by them and any future state which they are associated. And I got to tell you, before I give you the rest of the story, this is one of those cases that makes a great case to get rid of all of these mandated arbitration agreements allocated inside of private companies in particular, because it does waive your rights in a way. It does waive your absolute right to simply seek a remedy through the courts if the contract is drawn a particular way. So the plaintiffs argued in a 123-page filing on August 2nd, quote, as can be seen from the prior sentence, this argument borders on the surreal. As Law and Crime previously reported, Jeffrey Piccolo filed a wrongful death lawsuit in Orange County Circuit Court. This was back in February for his wife's death. Piccolo, his mother, and Tangsuan died at Raglan Road Irish Pub in Disney Springs. That was October 5th, 2023. They chose the restaurant because Disney and its staff assured them that the restaurant had proper safeguards to protect patrons from food allergies, according to the lawsuit. The lawsuit against Great Irish Pubs Florida and Disney World also states that Raglan Road advertises food allergy accommodations as a top priority, allowing guests to consult with a chef or trained staff. The plaintiff relied on these claims when choosing the restaurant for dinner. However, Tangsuan still died from an allergen or allergic reaction later that night. And that does not appear to be in dispute by Disney. Per the autopsy report, the medical examiner determined that she did die accidentally as a result of this ingestion. The report also showed that the doctor had very high levels of nut and dairy allergens in her system when she passed away. So Disney attorneys argued in May 31st, this was a motion that the family's lawsuit, alleging the deadly allergic reaction after dining at Raglan Road should be arbitrated. arbitrated. So Disney contends the lawsuit as alleging, quote, an agency relationship between landlord and tenant, and argues, quote, the only facts supporting this theory are representations about Raglan Road's allergen-free food on the Walt Disney World website, while noting that Piccolo alleges that he relied on the website when choosing the restaurant. But as the company filing goes on, it shows any further reference to the merits of the case, as Piccolo alleges in his complaint, much more important to the point of controlling the issues. In the case, Disney says is that Piccolo, quote, ignores that he previously created a Disney account and agreed to arbitrate, quote, all disputes against Disney or its affiliates according to the motion to compel. This gets crazy by the minute. The company's filing states facts it believes relevant, such as before dining at the restaurant, Piccolo created a Disney account when? He created the account November 2019. Agreed to the subscriber agreement and terms of use, and purchased part tickets, registering the decedent as his guest. He could not have completed those actions without agreeing to the terms and conditions. Believe me, it gets worse. The company's May 31st filing also references some legalese from that subscriber agreement. They claim is operative, fully operative right now. Disney argues that Piccolo agreed to let the arbitrator, not the court, decide on the interpretation and the enforceability of the arbitration clause, describing it as a broad delegation of authority. Earlier this month, Piccolo's attorneys filed a response containing some harsh language to argue against the arbitration bid. Quote, there was simply no reading of the Disney Plus subscriber agreement. The only agreement Mr. Piccolo allegedly assented to in creating his Disney Plus account, which would support the notion that he was agreeing on behalf of his wife or her estate to arbitrate injuries sustained by his wife at a restaurant located on the premises owned by a Disney theme park or resort from which she died. The family's response motion reads, frankly, any such suggestion borders on the absurd, end quote. Piccolo's attorneys also say Disney is actually wrong about the agreement their client signed. In a footnote, the lawsuit says the billion-dollar multinational company incorrectly relied on testimony that the Disney Plus subscriber agreement is between Disney DTC and or its affiliates by erroneously quoting language from the Disney terms of use rather than the actual subscriber agreement of Disney Plus. And the plaintiffs argue Disney is trying to enforce the arbitration agreement against the wrong legal entity. A court hearing in the matter is slated for October 2nd before the Orange County Court. Judge James A. Craner is on that case. Wow. Now, first of all, if this family did not have good attorneys to read through this mess and challenge the validity of the claim, they would likely be in trouble. They're already in conflict, chaos, and absolutely having to go through something they shouldn't. We already see that. So if this actually is a thing, and shame on Disney for even suggesting it, but if this is a thing, that means that everyone who subscribes to Disney Plus, even if you do the free trial membership, you have waived your right to civil remedy through the court if somehow you sustain an injury or a family member of yours has the ultimate and most extreme disaster happen, which is death. It makes me wonder, the fact that they came up with this argument, it makes me wonder, did they create the Disney Plus subscriber agreement in order to inoculate themselves from lawsuit in the future? Was that part of the plan? Because no one has ever made this kind of extreme argument that we've seen ever in case law. The attorneys are saying, not only is it a unique argument, it's a ridiculous argument. All right, Sharon, hell of a thing. Allegedly a responsible company doing something so extreme. It really shocks the conscience when you read the details of what they're trying to do in order to stop making an opportunity for justice for somebody that died under their watch.
Yeah, I think you're definitely on to something here, Doc, about the motivation behind this. I don't think you can call yourself this iconic family company if you're doing this. It's gross. And frankly, I'm fine to cancel. I've been through all the episodes of Dance Moms. I saw all that bad behavior. And I don't need to undertake this. It's devious. It's devious. You got the legal training, but I call it devious. I don't know if that's a term you'd use in court, but that's how it feels.
Well, definitely. We'll say shock to conscience, but it really does. Their legal defense is insane, and they're not even talking about merit of the case whatsoever. They have seemingly accepted liability, but they want a technicality here. All right, we'll bring you updates as they come.